road, it was off record, my road. My road, it was also off record. Really want it.
amounts by trial, amounts to trial by prosecution evidence allowing the belated introduction in at this advanced stage will constrain the prosecution to recall all the cases from that fresh technical evidence and all rights established for examination framework based on the new evidence which we need to finally, that pre-trial disclosure of witnesses and documents prior to commencement of an active case is crucial for a fair trial and is a means of discouraging and exposing fabrication, inaccuracy, and collusion by both parties. They ended by stating that the application should be rejected and dismissed. Both parties filed written submissions which are very powerful for a carefully read and considered them necessary without producing the same record. The issue before this court for consideration today is whether there is justification for grant of leave of court for the applicants to disclose additional witnesses and documents after the testimony of three key case witnesses. This is the determination of court. This application touches on the right to fair hearing. Article 28 of the Constitution of the Republic of Uganda, herein after the paragraph of the Constitution, broadly defines the right to fair hearing. Article 28 clause 1 provides that in the determination of civil rights and obligations, or any criminal charge, a person shall be entitled to a fair, speedy, and public hearing for an independent and impartial court or tribunal established. In the case of Bakalwakuta Mpasa versus Namboze Betibale Bachileke, election petition appeal number 49 of 2009, the Supreme Court in discussing the right to fair hearing stated that, and I quote, this right is so fundamental that it is given in Article 44 of the Constitution as one of those rights that are non-derogable. The Constitution appears to only give the salient features of what constitutes fair trial. It does not define the term fair trial. Because of its very importance, it is in my view that allegations of denial of the right of fair hearing or trial are very serious indeed and should not be made lightly or merely in passing. The impact on the very core of our trial system. End of quote. See also the cases of Paul King, Toliberi and others versus Constitution Appeal number 1 of 2002. Patosula versus Uganda. Court Criminal number 25. Azilia versus Constitution Application System of Great Street. Uganda versus Okumurigan and 5 others. Federal Revision number 003.
You are the tourist, you just.
Pre-trial disclosure, which is the duty to disclose witnesses and documents, is an important aspect of the right to fair hearing, which is premised on Article 28(3)(c) of the Constitution. It states that every person who is charged with a criminal offense shall be given adequate time and facilities for the preparation of his or her defense. As a fundamental aspect of fair hearing, pre-trial disclosure ensures fairness and prevents trial by ambush and miscarriage of justice. So as discussed in Sunion, Home, and One Mao, Constitution reference number 6 of 2007, Honorable Alan Sewan, versus Attorney General, Constitution petition number 4 of 2023. It is right that the right of fair hearing is not one that belongs exclusively to an accused person. It extends to all persons whose rights and interests are affected by the criminal process. See Faruku, Mohammed and others versus Attorney General and others, Constitutional Petition number 17 of 2024. Article 28(3)(g) of the Constitution in respect to witnesses states that every person who is charged with a criminal offense shall be accorded facilities to examine witnesses and to obtain the attendance of other witnesses before court. Section 76 of the Trial and Indictment Act provides that the accused person shall be allowed to examine any witness if the witness is in attendance, but he or she shall not be entitled as of right to have any witness summoned other than the witnesses whom he or she named to the magistrate's court committing him or her for trial as witnesses whom he or she desired to be summoned. Counsel for the applicants argued that the limitation under Section 76 of the Trial and Indictment Act applies only in relation to witnesses whose attendance must be secured through a summons, and that other relevant witnesses are exempted from the application of Section 76 of the Trial and Indictment Act, and calling them as witnesses is therefore unrestricted. I respectfully disagree with the position of counsel for the applicants that Section 76 does not restrict the substantial right to call witnesses after committal. My interpretation of Section 76 is that when there is a witness in court, from among those who were disclosed at committal, the accused person shall be allowed to examine them. That is as of right. In my view, Section 76 further provides that if any of the witnesses disclosed at committal are not in court, the accused person shall be entitled as of right to have such witnesses summoned. It could not have been the intention of the legislature that at any time and at any stage of the proceedings, any undisclosed defense witness sitting in court can be parachuted into the witness box and examined by the defense, even when there has been no prior disclosure to the prosecution. Therefore, save for witnesses disclosed at committal, the accused person shall not be entitled as of right to have any other witnesses summoned. Section 76 of the Trial and Indictments Act therefore emphasizes, in my view, the need for pre-trial disclosure. For an accused person to call any witnesses not previously disclosed at committal, the accused person ought to seek leave of court. In the matter before me, both counsel cited the Authority of Uganda versus Okumu Reagan and 5 others, where the High Court overturned a preclusion order in which the trial chief magistrate precluded prosecution witnesses belatedly introduced and disclosed after hearing commenced. Honorable Justice Stephen Mubiru held that in addressing an application for preclusion of a witness belatedly disclosed after the close of discovery, court should consider the following factors: the party's explanation for the failure to comply with the discovery order, the importance of the testimony of the precluded witness or of the precluded evidence, the prejudice suffered by the opposing party as a result of having to prepare to meet the new testimony, and 4, the possibility of a continuance. The applicant in this matter states that she has been charged with the offense of murder, and to further prove her innocence, she needs to answer scientific questions relating to the circumstances under which gunshot residue components were deposited on her hands and clothing, the circumstances under which her DNA profile came to be present on the trigger house, magazine and barrel of the pistol, the circumstances under which the door to the master bedroom said to have been locked came to be opened, and the trajectory of the bullet, specifically whether the entry wound was on the left temporal scalp area or the right ear canal, and the position from which the shot was fired. Further, that it was in the month of June 2026 that the suitable experts were found and contacted after efforts to identify suitable independent expertise relevant to the scientific issues were made by the advocates. Counsel for the applicant submitted that the said witnesses and experts sought to be disclosed only became known and available to the defense following further investigations and consultations undertaken during the preparation of the defense case. Further, that ballistics and gunshot residue analysis are highly specialized disciplines. Expertise in those fields is relatively rare and commonly found within police, forensic laboratories, and other state institutions.
that the identification of suitably qualified and genuinely independent experts was neither straightforward nor immediate, and that the delay in contacting the experts, is not unreasonable, as it is a consequence of the practical realities surrounding access to specialized forensic expertise. The prosecution countered that argument by submitting that the applicants had ample opportunity to identify, consult, prepare, and disclose all their intended witnesses, and ought to have identified and disclosed long before the defense case commenced. The prosecution, in my view, is working from the premise that the intended witnesses were readily available and agreeable to testify for the defense. In my view, however, availability of witnesses of such a nature in a case such as this is one thing, and engaging one and getting them to agree before court is another. It is presumable that even if the defense contacted all their intended expert witnesses in good time, getting them to testify in such a case would require extensive preparation before their acceptance to testify. As argued by counsel for the applicant, identification of genuinely independent expert witnesses for the defense cannot be immediate, as the core of the engagement is largely on critical review and interpretation of findings of another expert. In this case, experts who have already testified. It is therefore, in my view, not unreasonable for the defense to seek to call additional experts at this stage of the defense hearing. The principle of fair hearing demands that parties be given the opportunity to wholly present their case before a just decision can be made. Matters of adducing evidence go to the root of the principle of fair hearing. Honorable Justice Stephen Mubiru in the Okumu case noted that a decision of court barring a witness called by either party therefore has fair trial implications. The right to a fair trial entails the right to offer the testimony of witnesses, to compel their attendance if necessary, the right to present the prosecution's view of the facts as well as that of the accused to the court, so that it may decide where the truth lies. To ensure that justice is done, it is imperative to the function of courts that all necessary witnesses be available for the production of evidence needed either by the prosecution or by the defense. The ends of criminal justice would be defeated if judgments were to be founded on a partial or speculative presentation of the facts. In that case, my land senior brother also cited the case of Sun Yon, Kong, Kim, and another, where the justices of appeal were unable to give any hard and fast rule as to the time of disclosure in criminal trials because the circumstances of each case differ. That essentially, disclosure should be made before the trial commences, depending on the justice of each case and on which documents to be disclosed. This is entirely within the discretion of the trial court. On whether disclosure of the defense experts after testimony of 3 other defense witnesses will prejudice the prosecution, the calling of 3 other defense witnesses and the recording of their testimony will be after the prosecution has been disclosed to and given ample time to prepare to confront that evidence in court. Giving the prosecution ample time to prepare to cross-examine will meet the ends of justice. I have also had the benefit of reading the Kenyan decision in the case of Tom Onywamboya versus Republic, Criminal Appeal number 180 of 2023, as cited by counsel for the applicants, where the High Court overturned the decision of a magistrate in which an application to reopen the defense case to call additional witnesses before judgment was disallowed. On appeal, it was held that the court's decision was prejudicial to the appellant. This could have been remedied by allowing the defense to call additional witnesses and permitting the prosecution to cross-examine them before judgment. While the trial magistrate aimed to ensure substantive justice by concluding the case promptly, her actions in this instance prejudiced the application. Allowing defense witnesses would not have prejudiced the prosecution. Prosecution and prevent and rejecting the application to call additional witnesses would be to violate the applicant's right to fair hearing, considering the circumstances of this case and the fact that the defense seeks to call expert witnesses. However, note that court in this case has already had defense experts as follows: a pathologist who testified on his opinion about the entry and exit wounds, a DNA expert who testified on how, in her opinion, the DNA of Molly Katanga could have got on the pistol, and A1 herself, Molly Katanga, testified on how the door that was previously locked came to be opened. In the South African case of R versus Limbada, 1956, SA at 697, a party may call a witness belatedly. However, evidence which would merely be confirmatory of evidence already laid would not be admissible. In this case, therefore, I conclude by saying that I find merit in application and I allow it with the following orders. The defense will disclose to the prosecution the additional witnesses and all the evidence they seek to adduce by close of business on Friday, 24th July 2026. Evidence that has already been evidence on matters that have already been handled, insofar as it seeks only to be confirmatory, will not be admitted. So the evidence of the ballistics expert and the gunshot residue expert will be disclosed to the prosecution by close of business on Friday, 24th July 2026. The other witness whom the defense has not stated will also be disclosed. The defense stated that they had 3 witnesses, two experts and another witness who I presume is not an expert. That evidence will also be disclosed to the prosecution. But as I have stated, evidence that has already been collected, as I have noted, will not be repeated. We will not deal with evidence simply confirming what is already on the record. Okay.
Much obliged.
May it please you, my lord, we are calling 4 or 5. We are calling defense witness number 5. The witness would be allowed very short testimony, and for the record, Jet Tumwewaze, I'll take the witness through. And as usual, my colleagues are free to come in anytime. What religion do you profess?
I'm a Christian.
You're Christian?
Yep.
Okay. You're going to have to take oath.
You may, I see you're bending, you may leave here with the neck strain. You can adjust
Adjust to
Okay.
so that you don't bend.
adjust to your height.
Please hold the Bible and take oath.
I hold.
Please hold the Bible.
Hold the Bible, yes, and take oath. Follow her. Repeat after her.
I,
Your name.
Kulu Eric,
Swear in the name of the living God
swear in the name of the living God
that the evidence I shall give
the evidence that I shall give
before this honorable court
before this honorable court
is the truth,
is the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
What was the name again?
Kulu Eric.
Kulu.
Kulu, Kulu, then Eric.
I will start from there. So, my Lord, I want to pray that just to protect the witness. You know, the witnesses fear coming to court because by the time they leave, their pictures are all over. The media, I pray, my Lord, you direct the media not to publish his name and picture. They can publish everything he says, but not his name and picture in the yes. And his workplace. So the 3: his name, his picture, and his workplace.
Please, media, do not publish the picture, the name, and the
And workplace, yes.
of the
But
witness.
he will say them
You can
here.
say whatever
Everything
is
else you
said.
can say if you want. So,
When did the witness feel to have his name mentioned?
my Lord, you know, when they live here, you find your picture is all over the place and your name. And for some of them, there's a time I handled a case and somebody testified, and you can lose half of your clients. The public is different. The bashing is not only for okay. My Lord, it is happening, especially
Okay.
with social media.
All right.
Even as lawyers, we take hits, but for us, it's professional hazard. Even the prosecution does, but it's still professional hazard. But for witnesses, we don't have to take them through what we go through for our jobs. Again, you remind court what your name is.
My name is Kulu Eric.
Kulu.
Yes, please.
Okay. How old are you, Mr. Eric?
I'm EEK,
Limited.
Globetech Entertainment
Entertainment.
Limited. Yeah.
So how long have you been working as a photographer?
It's now 12 years. I started my journey in 2014.
2014, for 12 years. What photography do you do? Have you,
Okay.
what kind of photography?
As Globetech, we do corporate events, we do weddings, birthdays, and mainly we have covered most of the government entities.
You have covered what?
Government entities,
Like,
prisons,
like
the judiciary. We have done the swearing in for the president. Yes, that's the little background that we have.
So do you have any specialized training in photography, or is there a college, is there, you know, what or something, what, or you have?
Okay, my journey in photography, I didn't go to school for it. I learned on the job.
Learned on the job.
Yes.
Where is your company located? Where is your company office?
Okay, before our company was located at Serena Hotel at the conference side, but since now it is under renovation, we temporarily shifted to Mbuya, where Zone 7 is. For now, that's where it is located.
Okay. So, enough of the background. So how do you, this case, how did you get to be involved in this case? As a photographer.
Okay. My involvement in this case, I was contacted by my boss, since I'm an employee of the company, that we had a shoot that we had to do. On that very day, he called me in the morning. So it was an evening shoot that we were going to do. And on that, it was around 6. Oh, before that, before 6, it was around 2 when my boss called me that we have to be set, so that by 6 we have to be at the place we are going to take the pictures from. And on that, by 6 we were at the venue. It was some residence.
Where is the venue?
It was a residence in Mbuya. As you at the hill, as you're going up the hill, on the right side there was a black gate.
On the right side.
My Lord, we are constrained, and not that our colleagues should not lead any witness, but my Lord, this witness is completely strange to us, and it is not fair. My Lord, this court has emphasized we should not ambush each other. Completely strange, my Lord. His is not named, even in the things that they disclosed. His name is not anywhere, my Lord, and we are struggling to understand what exactly the defense is doing, or what piece of evidence from what they disclosed to us. And my Lord, why the defense has found it extremely difficult to name, because the law talks about naming. The purpose is we are all prepared, and then we are not taken by surprise. My Lord, we have no evidence that this gentleman was named to us. With due respect, my Lord.
My Lord, I didn't know that one day I would hear my colleague complaining about disclosure. It became our song for 2 years when we were asking them to disclose. But nevertheless, my Lord, we disclosed the witness. We disclosed this witness is a photographer. We disclosed the photographs that he took.
When did you
And
disclose?
his name, on the 13th of May 2026, we disclosed the photographs, and his name is on the photographs. And my Lord, it is clearly there, acknowledged by Ann Kiza, the letter we have on the 13th of May 2026, among the things we disclosed and received and acknowledged by Ann Kiza, our learned colleague, on the letter. So we are using the letter, but you can see. So it is acknowledged there. Among the things which are white.
Yeah, let them look at it.
Which one? Hold on, let me finish. But why?
I thought you had finished.
No, my Lord, I was going to read, my Lord.
Okay.
Yeah. Among the items we disclosed, it is defense disclosure number 2. Among the items were a Sandisk 8 GB silver flash disk containing 112 digital photos from the Katanga home. And on the photos, his name is there. So my lord, we disclose it. So
Let them look at the letter.
Just remove the letter. Don't give everything. We are going to give you the letter, Mr. Mwaganya. Why have you all of a sudden become urgent for this case which you have delayed for years? So take a picture. As usual, take a picture. And my lord, you remember the lady who recorded More Katanga's evidence? What witness was that? Naruze Rashida. She turned up here. Even Mubiru turned up. Everybody turned up.
Mr. Tumwebaze, let's first address this issue.
My lord, remember by the 13th of May 2026, when Dr. Nzvua was on the stand, we asked for the disclosure of the article that he was referring to. Article. My lord, by that time, defense disclosure was closed. The article that we requested, my lord, was on the stand during cross-examination. And then, other than the doctor giving it to us, KAA undertook to say they will do it themselves. And by so doing, my lord, in addition to the article, they also disclosed other things without leave of this court, including what they are referring to as a SanDisk 8 GB silver flash disk containing 112 digital photos from Katanga Mole. My lord, we indicated to our colleagues that any such disclosure without the express leave of this court, in a breach of the disclosure rules, we were not going to even touch it. My lord, we are all bound by the rules of fair play. We couldn't have required a specific article by Dr. Nzvua. That publication that they ended up also giving us a different one, but at least we needed an article. And then the defense choose, in addition to the article, to disclose other things. My lord, we received that flash because by the time our colleague was signing for this, our focus was on the article. Then later, when we learned that they disclosed things beyond the article without leave of court, we disregarded it. My lord, that particular belated disclosure, we should have been a subject of the application that, my lord, you have just traversed. It was passed over in breach of the rules of disclosure. It has not been regularized at all. But also, most importantly, even with those photos, my lord, he is not named as the photographer. Even if we had looked at them, honestly, we have not, because we had no reason to even look at them. We have no obligation to consider things that our colleagues are doing in bad faith and in breach of this court's rules. But even then, I believe that photographs would never have indicated Mr. Kulu Eric as a potential witness for the defense. My Lord, all we are praying for, and we humbly seek the indulgence of this court. Let us stay clear. Let us observe the rules of fair hearing. And as far as we are concerned at this point, that things were passed over in breach of rules, we have never touched them or considered them. The defense, in its wisdom, has not even sought to regularize that belated disclosure. They even made no mention at all in the application that my Lord has just disposed of. My Lord, they cannot proceed in breach of rules of fair hearing. This witness was not named. He was not named anywhere as a photographer. We couldn't have expected Mr. Kulu Eric as a photographer or as a witness to talk about anything relevant in this trial. My Lord, we seek for your indulgence.
My Lord, there's a lot of misinformation, surprisingly shocking misinformation that has come from my colleague. My Lord, the facts as to this case is that we attempted to serve that flash disk in this court. Mr. Mwaganya rejected it before you, my Lord. We asked you if he can serve it. He told us to serve it at the office. It was then served at the office. When served, my learned friend Ms. Kiza wrote the following: I, Anna Kiza, acknowledge receipt of the above defense disclosures on behalf of the Office of the Director of Public Prosecutions. My Lord, this is on the 13th of May, 2026. She received it on the 14th of May, 2026 at 2:19 p.m. My Lord, when we talk about, my Lord, the court can have a look at the letter. My Lord, when we talk about the application, my Lord, it is only after we made contact with our colleagues that they refused to receive subsequent disclosures that we came to this court. My Lord, the DPP cannot receive on behalf of the DPP evidence and then come to court and say that the evidence they received should be closed. My Lord, in the application that you have just ruled, that letter was put as an annexure. Again, my learned friend, Anna Kiza, is the one who deposed an affidavit in response. My Lord, the DPP had an option. When we offered him the flash disk in court, he refused it and asked us to give it to him at his office. When we offered him the evidence of other experts, he refused them and asked us to make a formal application. For this particular piece of evidence, the DPP acknowledges that they have received it, the time they have received it, and they properly describe it as defense disclosure. There is no basis in fact or law for the DPP to now try to suppress evidence that has been in their possession for 2 months. They claim that pictures will not show is a question of evidence. We have said the pictures will show on them his name written there. So unless they wanted us to give them a witness statement, which of course they refused to give us witness statements of witnesses that came here. So my Lord, it is clear my learned friend received disclosure. She did not receive, there's nothing there about Dr. Nzivua. It is very clear. She's received disclosure. And she has signed that she received disclosure. And she had the option to say, I am accepting one, I am rejecting the second one. My learned friend cannot now come and tell us what they should have done there. 2 months. They could even have written back and said, we received this letter in error, we reject it. We put it on an affidavit in this court. They could have in response said, we gave you this thing in error. My Lord, the signed page is here. Signed incidentally by my learned friend. So my Lord, it is actually unfair to try and suppress this evidence coming to the court when they have had it for 2 months. They could have objected before. There is nothing they didn't know. They've even led some witnesses on it.
They objected to experts.
My Lord, with due respect, it is not that we are afraid or even moving to suppress any evidence. Our colleagues can call any evidence of their choice, my Lord. We are not afraid. We are only saying, my Lord, that at the very least, my Lord, we should observe the rules of these proceedings, my Lord. Indeed, my Lord, when the defense attempted to give us a flash with photos, we rejected them because they were moving to disclose things belatedly against the rules of this court and without leave of court. My Lord, we rightly rejected. I can go on record. I rejected. My colleagues did reject. Now, having rejected for those reasons which we indicated to them, my Lord, now we cross-examine Dr. Nzivua and ask for a document, and they tactfully now say, we shall write and disclose to you. And other than disclosing the document of Dr. Nzivua, they also include a flash disk. My Lord, an illegality can never pass the test by application of tactics. So the question here, my Lord, is one, when did the disclosure for the defense close? My Lord, disclosure closed before defense witness number 1 was put on the stand. The only exception that has come in, my Lord, has been today by leave of this court. So, my Lord, if disclosure had closed before DW1 testified, under what exception did our colleagues attempt to disclose additional evidence in the middle of the trial without the leave of this court? My Lord, it is not about being tactical. It is about being professional and being truthful to the calling of this court. My Lord, unless this court authorized them to make that belated disclosure, they cannot accuse us of wanting to suppress evidence. My Lord, this court cannot sanction action in bad faith. We should proceed fairly, with openness. We owe a duty of honesty to each other, but most importantly, my Lord, to this court. To this court.
Thank you, Mr. Morgan. Section 76, I'll read it again. The accused person shall be allowed to examine any witness if the witness is in attendance, but he or she shall not be entitled as of right to have any witness summoned and other witnesses whom he or she named to the magistrate's court, committing him or her for trial as witnesses whom he or she desired to be summoned. I've already given in the ruling what my understanding of this provision is. And the accused person shall be allowed to examine any witness if the witness is in attendance. In my view, this is if the witness is one of the witnesses who was disclosed at the time of committal. If there are any witnesses who are not in court but they were disclosed, they can then be summoned. I do not believe that it was the intention of the legislature that at any time, at any stage of the trial, a random witness sitting in the gallery can be presented as a witness without leave of court. In this case, and this is the circumstance in this case, leave of court ought to have been sought for an additional witness, just as the application has occurred. The fact that a flash disk accompanied a request for information at a stage, the flash disk accompanied the request for information of the article that Dr. Onjivua referred to.
My lord, my lord, the fact is, my lord, the fact is that the flash disk was given. My lord, let me speak.
Overrule court.
My lord, my lord, I pray that I be given a minute to speak.
With leave of court.
With leave of court. Much obliged.
But Section 76 does not envisage that anybody sitting in the gallery can be disclosure of witnesses and evidence after committal by Section 76 is to be with leave of court, to ensure that there is the right to fair hearing on both sides protected.
Okay, so my lord, now the fact is as follows. That flash disk was passed on to my colleagues. My lord, no, don't gag me. You have no right to gag me.
Mr. Mwaganya.
Yes, my lord, Mr. Mwaganya has no right to gag me. My lord, the fact is that flash disk was provided in this court and the prosecution said, serve it at the office. The fact is my learned friend, Mr. Savani, provided that flash disk to the prosecution and they went through those photos one by one, counting them. That is a fact.
Here in court?
No, my lord, in court we asked you if we could give it to them and they said we take it to the office and the court agreed.
Do we have a record of what it was exactly?
My lord, you can get the record. When Dr. Nzivo was here, we prayed to serve them a flash disk.
Of what?
We get a flash disk of the photos.
Of photos relating to?
Yes.
Photos relating to?
Yes. No. My lord, we were very specific that we want to disclose further evidence. They then said they cannot receive it from here.
But it should have been with leave of court by Section 76.
Now, my lord, I want to come to that point of Section 76. My lord, at the close of the trial, the prosecution objected to us calling any witnesses because we had not disclosed during the Section 76 process. And my lord, you guided and said we should disclose our documents and our evidence. That is what you said, my lord. When we wrote to them, we told them it is continuous. They accepted.
No, the continuous. Let me make.
No, my lord, let me just finish my sentence.
Let me clarify about continuous disclosure.
No, my lord.
Continuous disclosure is in the context of things that come up in court, like cross-examination. You cannot claim continuous disclosure for other matters that you could have reasonably expected.
My lord, I misspoke. I'm not talking about the continuous disclosure that you ruled on. That's what I'm talking about. I am saying that when this court found the accused persons with a case to answer, prosecution told my lord that we haven't disclosed a single witness at committal. Therefore, we cannot. This court then guided, allowing us to make disclosures to them. My lord, it was only when they objected at our third attempt at disclosure that this court then asked us to make a formal application on the part of the evidence that had not been disclosed. So this evidence, my lord, fits into that first batch. This court gave us time, but we were very clear that for us we shall need more time. They accepted this one, my lord. And they looked, my lord, it is not true that a flash disk was given to them blindly. My lord, they looked through and counted 114 photographs. They did. Before they received it.
Let me ask.
After that.
What is the process for receiving? The person who received this here.
Yes.
You just receive or you look at what you receive?
Because there's a specific allegation of 114 photos. And my lord, the person who gave her is also here.
Mr.
They don't just receive documents at the DPPs, they cross-check them.
I did receive the documents that he brought. He brought them to my office with a flash. There were documents of Dr. Onzivoa that we had requested for in the court. There was a flash. There was something in the envelope, so I asked him, what do you have in the envelope? It was stapled onto the letter, and he said, it is a flash. I said, hey, okay, fine. So I signed, and that was it.
No.
So it was later, while we were in the office, later that we discovered that there were over 100 photos. But on that day, when we signed, the flash was not checked.
No, my lord, that is untrue. The article of Dr. Nzivo was in hard copy. The article on Dr. Nzivo was a hard copy. It's the pictures that were on a flash. And she went through all of them, my lord. She went through all 112 photos of them. My lord, it is very clear. It is two things that were disclosed. But Mr. Savani is here.
Mr. Karuhanga, were you there when she was receiving the one?
My lord,
and going through them?
my lord, that's the procedure we have been doing. My lord, no, Mr. Savani is here.
We have never served.
Mr. Savani is here. So, my lord, the issue of Section 76 is not the issue before you. Because this court allowed us to make those disclosures. What happened is that they then received the disclosure. So the question is whether they can approbate and reprobate. That is the question. How do you receive evidence? My lord, she wrote here, I, Anna Kiza, acknowledge receipt of the above defense disclosures on behalf of the Office of the Directorate of Public Prosecutions. So now how then can you now say that this is an ambush? How then can they, my lord, the only unfairness would be to stop us from leading evidence that has been disclosed to these people. They have this evidence, they should confront it in cross-examination. They cannot receive it and then deny receipt of it. My lord, my lord, I have been with these people. You cannot receive anything that is not gone through. And my lord, that is why it is signed. And the disclosure is very clear. It is not correct for my colleague to come to this court and say that she received a flash disk which had a PDF. The disclosure is very clear. One was a hard copy article, PDF article, hard copy. The other one was seen photographs, SanDisk 8 GB, silver flash containing 112 digital photographs. And my lord, it is clear that they received a hard copy. So my lord, it is not about Section 76. My lord, it is not true that someone has been parachuted. My lord, someone has been disclosed to these people for 2 months. So the question is quite simple. Are we going to suppress this evidence or not?
My lord, Mr. Tumwebaza and Mr. Karuhanga, you hold your horses. Yes, can I say something?
Thank you, my lord. We are not up to suppressing any evidence whatsoever. And in fact, we have no worry about whatever witness that they may wish to bring. Our only request is one, that we all act in honesty and fairness. My lord, if you may recall the day you walked out on us here, that was the day. And we were acting, that day ended. Can I finish?
Let her finish.
My lord, my lord,
let's not quarrel in court, please. Let Miss Wakoli speak. Yes, Miss Wakoli.
Thank you, my lord. On the day you left us, that was the second incident from the previous one. The court on that day ended in a very chaotic manner after Onzvua. And the reason why it ended in such chaos that day was because Mr. Karuhanga wanted to disclose more information, and we vehemently objected to it. And that is what caused the chaos, and that is how it ended. So it became apparent that by that time, we were not willing to receive any other disclosures without the leave of court. And when that document was, when they brought that letter, if you, my lord, if you look at those dates, the defense hearing had already started. We were at another witness, and when the cross-examination of Dr. Onzvua, that is when we requested that article. So in all honesty, when the documents were brought, and even when Anna brought me this, she told me there is a flash, and I believe that it could be even the soft copy of what they have given us in a hard copy. So when later we found, when I opened the flash, hoping that could be the other articles that Dr. Nzivua had referred to, I was also surprised to see the photos. I asked Anna what could have happened. I said, no, the gentleman who brought it just told me that there was a flash attached. So that's how she comes to sign about it. So we needed to also be fair and transparent as officers of court, even when we are doing this work. So you cannot, even if you looked at those photographs themselves, they wouldn't also state that he was the photographer. From all the disclosures that we received at the beginning of the hearing, this particular witness was not among. He was not named, he was not among, and they thought of him later towards the end of Dr. Nzivua's evidence. And that was the reason why we did the objection on that day. So we refused the whatever additional disclosures. And our understanding of the law was that since hearing has commenced, any other further additional evidence or disclosures have to be with leave of court. And we have not received any leave of court save for this morning. So we are obliged, my Lord, to your guidance, but as far as we are concerned, we haven't received any disclosures of any relating to this witness. And if they really feel that this witness is a very important person and they would wish to have them, then let them provide us with all the information that we require, and we prepare for his evidence.
My Lord, I'm sorry,
seek
but
leave formally to have his evidence disclosed formally. We will receive it, my Lord, and we will prepare for his cross-examination.
my Lord, everything my learned friend has just said is untrue. Everything.
Now,
My Lord, if I can, the day we had the disagreement here, my Lord, if I can just give 1 minute. My Lord, just 1 minute. My Lord, just 1 minute. Yes.
I can see that we are likely to degenerate into
Yes. But my Lord, all I wanted to say is that the day this court left, it was when Dr. Sechimpi was here. Where is my file?
We objected when Naruze came here. Naruze came here. We saw Mubiru came here and we didn't know. Mubiru turned up. Naruze came, Mubiru came. These guys just show up like that. And then you were saying,
You see, what happened? Hey.